Hello bar takers, my name is Lisa Duncanson. I'm the bar exam guru and I'm here today to bring you another Bar Minutes video. These Bar Minute videos are approaches for topics within the testing areas of the bar exam. So today we're going to look at one of the areas of property law that gets tested quite a bit typically, but we haven't seen in some years, and that is the area of easements. So easements are not an ownership interest. It's referred to as a non-possessory interest in land where the owner, the possessor, has acquired some rights to the land, the owner of the easement, not the owner of the property. So the person who has the easement is in a dominant estate and has an easement over the servient estate, meaning that that estate serves the dominant estate. So typically it's a pathway. It could be a road, it could be a path to a lake, it could be the only way that someone could get off of their property. So that would be an easement by necessity. So we're going to go through all the types of easements and most importantly an approach. So the first thing you want to do is you want to address the general rule for easements. So an easement is a non-possessory interest in land whereby the easement holder has an interest, has a right to pass through that land or to do something on the land. And this is how you can get into a license situation, which we'll talk about a little further down. But stick with the easement. The general rule is it's a non-possessory interest in land where the holder of the easement has a right to use the other person's land. And the other person's land would be the servient estate serving the dominant estate, which is the piece of land where the owner has, or the person who possesses that land, has a right of way on the servient estate. So your approach for easement should be to state that one sentence rule, general rule about easements, that it's a non-possessory interest in land. And then you go on to the next step, which is to determine whether the easement is an appurtenant easement or an ingross easement. And I can tell you that on the essay exams, it's typically that you're dealing with an appurtenant easement. What that means is that you have a dominant and a servient estate. The dominant estate is the owner of that land or possessor of that land has the right to walk or pass or do something on the servient estate. The next step, well, that's appurtenant. Ingross is more akin to a license. So it's a personal easement if you have an ingross easement, and it isn't related to a dominant or servient estate. It's simply someone has the right to go there either to pick fruit or to get to a swimming location or to access something, but we don't have two pieces of land that are adjacent and appurtenant. So typically what's tested is an appurtenant easement. If you have something that's ingross, that means that it's personal to that owner of the easement, not to anyone else, and it can be something that could be turned into or dealt with under a license concept, and we'll get to that in a bit. The next step is to identify whether it's an affirmative easement or a negative easement. Affirmative easements allow someone to do something on the servient estate. A negative easement requires a person to refrain from doing something on their estate. Easements that are negative could be for air, light, that kind of thing. Typically, what the bar examiners in California are testing are affirmative estates, not negative. Then the next step, you go to how the easement was created. Now here's where a lot of people make a big mistake and lose points. Instead of identifying multiple ways that the easement could have been created, they stick with the one that they know is there, okay? And that might be an easement by express grant. Great. So an express grant easement is one that is put in writing and hopefully is recorded. But of course, on the California bar exam, it usually isn't, which requires the examinee to then look at notice, actual inquiry, and constructive notice, which really bothers people for some reason, but I can tell you how to handle this really simply. So with creation, you can have an easement by prescription, which is really essentially adverse possession for the easement. And you can also have easement by implication, which is usually based upon prior use. So we don't have an express grant situation, but we have someone continually using the land, which would sort of give you maybe a basis for adverse possession, but perhaps it's only by implication, because adverse possession has a period of years that has to be met, which is usually 20 years. You won't be told this on your fact pattern, but for adverse possession, a prescriptive easement to be made or created, there has to be that statutory period met. So typically you might then resort to an easement by implication by prior use. They used it and used it and used it. The other way that you can get an easement is, of course, by express grant, which has to be a written document because it deals with land, and you should record it, but on the bar exam it's typically not recorded, so that then they can test you on the recording statutes and notice. And the other way that you're always going to write down as a throwdown is an easement by necessity, especially if the bar exam fact pattern doesn't mention that the land is landlocked. You're going to address any of the ways that an easement could have been created: implication, prescription, which is adverse possession. And here, while there are no facts that suggest that Nellie's land is landlocked, should it ever be landlocked, she would have an easement by necessity, and that easement would end when the necessity ends. And you always want to include that. If you've watched our other previous video on contracts, one of the things that you need to always address is statute of frauds. Even though it may be met, it's a defense to formation, and they want you to throw it down on the exam. This is the same type of thing. With an easement exam, you need to address as many possibilities as you can for the easement to be created, even if the facts don't generate it. Now, that doesn't mean that you talk about all of them: prescription, implication, necessity, and express grant. If you don't have it by express grant, then you can't talk about it. You can say here it was not created by an express grant because there was nothing in writing granting, Nellie or whoever the easement or right of way. The next step after creation is to look at the scope of the easement. And you can address this or not, but I would recommend that you address it. But you have to address it if there is a burdening or an extension, an overburdening potentially of the easement. And by that I mean, maybe it was a 10-foot wide road that was gravel. And over the years, the user, the dominant estate who used that pathway, that road, paved it and added 5 more feet. And maybe it was primarily a residential easement, and now it's partially commercial. So the rule with respect to an easement and whether the easement is terminated by overburden of the easement holder is that if it becomes 100% commercial, and it was part residential, part commercial, or just residential, then that terminates the easement holder's rights, and they will not have an easement. But that's not how the bar examiners are going to test it. That's just the rule. What they will test, if they test this area of easements, is they'll give you a scenario where there are some commercial traffic. There's some commercial traffic on that property on the road, and now the owner of the dominant estate paved it, added a few feet to it, and has increased the commercial traffic to the point that it's obviously annoying the Serbian estate, but it's not 100%, it's about 70%. And they'll also add in a little factor too about how the whole community and the city, the area has become more and more commercial. That doesn't matter. The fact that the neighborhood or the area where that land, the Serbian estate, exists has become more commercial does not require the owner of the Serbian estate to become more commercial in what they allow. So it could be an overburden of the easement such that it would terminate the easement. So you need to be aware of those things, and you should always address scope, but you have to address it. It would be a fail if you don't address it when you have a situation where someone's paved the road, extended the width of the road, or done something to the pathway, changed the traffic from residential to more commercial. Things like that will tip you off to scope being a major issue on your easements exam analysis. The next thing you want to look to, if it's an issue, is transfer. Now, how does transfer of an easement become an issue? Transfer of an easement becomes an issue in a land sale contract. So you're never going to have an easement essay that is just easements. I'll tell you that easements is tested in conjunction with many things, but the most popular way that it is the most frequent flyer for easements is in the context of land sale contracts. So you have buyer who is a BFP, meaning a bona fide purchaser, someone who paid value for the land. And if they had actual notice, if they had notice, let's just say notice, because actual is just one type of notice. There are 3 types of notice that a BFP could have. A BFP is someone who pays value and has notice of the easement. If they are that person, then they take the land subject to the easement. If the buyer paid value but had no notice of the easement, then the easement is extinguished. But here's what the bar examiners do. They don't make it that easy. It's a little trickier. So let's talk about, so we can get into that trick, let's talk about the types of notice that you have in this setting. You have something called actual notice, you have something called constructive notice, and you have something called inquiry notice. Actual notice is the seller says, hey, the neighbor over there uses this road to cross over to the lake, or this pathway to walk over the lake, and she's been using it for 20 years. Doesn't have to be 20 years, but whatever the facts are. In that situation, that's actual notice. Constructive notice is when the grant or the easement, which would be in writing, the express grant, has been filed. So in other words, it's been recorded, and anybody who's doing their due diligence on purchasing a property will check with the recorder's office to see if there are any liens, if there are any easements on that property. So if they fail to do that, they're held to constructively being notified, constructive notice. Inquiry notice is what's most often tested. So inquiry notice is not an express grant. It's not actual notice where the buyer was told about the easement, but it's evidence in the fact pattern that anybody looking at the property would see someone's been camping here, or there's a pathway that's worn down that goes from this property to this end of the property, and someone's been using that. So that's inquiry notice. There's something about the property that should, if they looked at it, and they're buying it, so they would look at it, would suggest to them to look further, inquire about that. Ask the seller, check the records, but there won't be likely an express grant in that setting where they're testing you alongside a land sale contract. So hopefully that makes sense. I think it's really important to move away from these long outlines that do not tell you how things are tested. It's great to know the law, But if you don't know it in the context and to know what the bar examiners are expecting from you on exam day, it's a fail. That's plain and simple.